Now let's unpack the legal implications of the case. I'm joined by lawyer and former prosecutor Stephen Dreyfuss. Stephen, thanks for joining us. In terms of the charges, there's 34. Which ones have stood out for you if you've had a chance to unpack any of them?
I've only just seen it and I've read it. The first thing that happened is that Trump's lawyers had a news conference and criticized the fact that it's bare bones. That's the way indictments are in the state courts in New York, contrary to the federal courts that some people are used to. But at the same time, there was a 13-page statement of facts that was released by the prosecutor, which he no doubt will talk about at his upcoming press conference, which made much clearer what the purpose of the payments was and how they were done. The indictment itself just contains 30-odd counts. Each false entry in the business records of the Trump organization is charged in a separate count, but there isn't much information in there. The information is in the statement of facts, and it seems clearly to allege that the money, $130,000, was paid to Stormy Daniels, and then it was mischaracterized on the business records of the Trump organization as payments of a retainer to Trump's lawyer, Michael Cohen. And Trump himself signed 12 monthly checks repaying Michael Cohen for the $130,000 that Michael Cohen advanced out of his own pocket. Indeed, he took a mortgage on his house to do it. So that's the essence of the charge, but there will be no doubt much more evidence produced in the event that there is a trial. And the next step is going to be motions by the defense to try to dismiss or limit the indictment. But assuming that some or all of the charges remain, after those motions are decided, then the trial will take place, we're told, in the beginning of next year.
As you mentioned, Stephen, it's a bit early to say what kind of argument the defense will put up in terms of that rebuttal against the charges. But what do you expect them to say?
Well, I think what they'll say is that there are all kinds of legal objections. They'll say that it's barred by the statute of limitations, that it was improper to use a federal charge as part of the basis of a state indictment, all kinds of technical arguments. But on the merits, I don't know what they'll say, because there is a lot of documentary evidence that corroborates the allegations of the prosecutor. I suspect that the major defense will be that this was done by people working for Trump without his knowledge or without his direction. Because Trump traditionally has given very cryptic orders to people that are not written down to do various things so that perhaps he can evade responsibility later on. And the challenge for the prosecutor will be to show that Donald Trump knew about this scheme and directed it, agreed to it, consented to it, et cetera. They certainly will be able to show that he knew that he was paying the money back to Cohen. But whether he knew about the original plan to conceal the character of these payments, to make them seem like payments to a lawyer rather than payments to a porn star, that remains to be seen. And I suspect factually that would be the major defense that would be raised at a trial.
So in terms of an arrest and then ultimately seeing Trump in jail, how likely is that?
Well, he's been arrested and he's been released on his own recognizance. Under New York law, this kind of a charge would not permit somebody to be kept in jail pending trial. And the question will be whether the prosecution will be able to convince a jury of 12 people unanimously to convict him of these charges. What the sentence might be after conviction is a whole other discussion. But the big issue will be, are they going to be able to convict him? And it will be up to a jury of 12 New Yorkers from Manhattan. This is only the county of New York, which is Manhattan, to decide whether his guilt has been proved beyond a reasonable doubt or not.
And of course, it is 12 people, and it almost makes a man who was at the apex of power in the world, it almost makes him seem a little bit more human that it is 12 jurors who are going to be determining his future. But what kind of legal precedent do you think this sets for the office of the President of the United States?
I don't think it sets any precedent, frankly, because one thing one can say about Donald Trump, whether you're for him or against him, is that he has broken the mold of what presidents were up until he arrived. And there was never a prohibition for indicting a president after he's out of office. There is simply an internal policy of the Department of Justice that they don't bring federal indictments against the president while he or she is in office, because the sole remedy should be impeachment of a sitting president. For a president out of office, there is no limitation. There never has been. There just hasn't been yet somebody whose conduct justified it. I see the prosecutor Bragg is arriving at the podium, so perhaps you want to go to him.
Yes, absolutely. Well, we do have Alvin Bragg now, the DA from Manhattan. Let's turn to him right away.
On a New York Supreme Court indictment returned by a Manhattan grand jury on 34 felony counts of falsifying business records in the first degree. Under New York state law, it is a felony to falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct. The defendant repeatedly made false statements on New York business records. He also caused others to make false statements. The defendant claimed that he was paying Michael Cohen for legal services performed in 2017. This simply was not true. And it was a false statement that the defendant made month after month in 2017. April, May, June, and so on through the rest of the year. For 9 straight months, the defendant held documents in his hand containing this key lie, that he was paying Michael Cohen for legal services performed in 2017. And he personally signed checks for payments to Michael Cohen for each of these 9 months. In total, the grand jury found there were 34 documents with this critical false statement. Why did Donald Trump repeatedly make these false statements? The evidence will show that he did so to cover up crimes relating to the 2016 election. Donald Trump, executives at the publishing company American Media Incorporated, Mr. Cohen, and others agreed in 2015 to a catch and kill scheme. That is, a scheme to buy and suppress negative information to help Mr. Trump's chance of winning the election. As part of this scheme, Donald Trump and others made 3 payments to people who claimed to have negative information about Mr. Trump. To make these payments, they set up shell companies, and they made yet more false statements, including, for example, in AMI, American Media Incorporated's business records. One of the 3 people that they paid to keep quiet was a woman named Stormy Daniels. Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The participant scheme was illegal. The scheme violated New York election law, which makes it a crime to conspire to promote a candidacy by unlawful means. The $130,000 wire payment exceeded the federal campaign contribution cap, and the false statements in AMI's books violated New York law. That is why Mr. Trump made false statements about his payments to Mr. Cohen. he could not simply say that the payments were a reimbursement for Mr. Cohen's payments to Stormy Daniels. To do so, to make that true statement, would have been to admit a crime. So instead, Mr. Trump said that he was paying Mr. Cohen for fictitious legal services in 2017 to cover up actual crime committed the prior year. And in order to get Michael Cohen his money back, they planned one last false statement. In order to complete the scheme, they planned to mischaracterize the repayments to Mr. Cohen as income to the New York State tax authorities. The conduct I just described and that which was charged by the grand jury is felony criminal conduct in New York State. True and accurate business records are important everywhere, to be sure. They are all the more important in Manhattan, the financial center of the world. That is why we have a history in the Manhattan DA's office of vigorously enforcing white-collar crime. My office, including the talented prosecutors you saw at arraignment earlier today, has charged hundreds of felony falsifying business records. This charge, it can be said, is the bread and butter of our white-collar work. And fraud presents itself in all different forms here in Manhattan. We have charged falsifying business records for those who violated federal bank secrecy laws. We have charged falsifying business records for those who were seeking to cover up sex crimes. And we have brought this charge for those who committed tax violations. At its core, this case today is one with allegations like so many of our white-collar cases. Allegations that someone lied again and again to protect their interests and evade the laws to which we are all held accountable. As this office has done time and time again, we today uphold our solemn responsibility to ensure that everyone stands equal before the law. No amount of money and no amount of power changes that enduring American principle. I'll now take questions.
So we're going to take a limited number of questions. There are no follow-up questions. One question per reporter. I will call on you. And again, we have limited time. Thank you. The first question will be Rick.
Thank you. Brittany Russell, CNN. Why now? I mean, some argue that this is a political move. You're not going to be a political person. The court dates are going to go into
We conducted a thorough and rigorous investigation, as we're known to do, at the Manhattan District Attorney's Office. I've been doing this for 24 years and am no stranger to rigorous, complex investigations. I bring cases when they're ready. Having now conducted a rigorous, thorough investigation, the case was ready to be brought, and it was brought.
Mr. Bragg, the indictment says that there were 34 false business records. And they were done to conceal another crime, but the indictment does not specifically say what those crimes were. We are assuming, perhaps, that they might be election-related. I'm wondering if you can specify what laws were also broken.
All right. So let me say as an initial matter, the indictment doesn't specify that because the law does not so require. In my remarks, I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits.
But why weren't there those crimes charged? Why wasn't he charged with those crimes?
Well, I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
Hi, Mr. DA. You had expressed a year ago that you had some reservations about the case's readiness. Can you talk to us about what were some of the questions in your mind that needed to be answered in order to bring a case of this magnitude?
I'm not going to go chapter and verse into any thinking. What I will say is, I believe the time period you're talking about, I've been in office for a couple of months. The investigation, in my view, was not concluded into the conduct in particular that is the basis for the charges today. Since that time, we've had more evidence made available to the office and opportunity to meet with additional witnesses. So, as I said earlier, I've been doing this for 24 years. I don't bring cases prior to a thorough and rigorous investigation. Now, having done so, the case has been brought.
Mr. Brad, Garrett Hake with NBC News. Your predecessor took a hard look at this case and decided not to charge it. Federal prosecutors took a hard look at this case and decided not to charge it. Do you believe you have new evidence that led you to decide to charge this, or why now?
Well, as I just mentioned, we have had available to the office additional evidence that was not in the office's possession prior to my time here. And as to your part of your question about the federal, we have a distinct and strong, I would say profound, independent interest in New York State. This is the business capital of the world. We regularly do cases involving false business statements. The bedrock, in fact, the basis for business integrity and a well-functioning business marketplace is true and accurate record keeping. That's the charge that's brought here, falsifying New York State business records.
We're gonna take two more. Yep.
Thank you. DA Brad, I'm just going to read back one line from your statement of facts. The participants also took steps that mischaracterized for tax purposes the true nature of payments and furtherance of the scheme. Do you allege former President Trump was one of the participants who mischaracterized the payments for tax purposes?
I'm not going to go beyond the plain language statement of facts, which I think speaks for itself.
Brad, can you please comment on the strength of the evidence that Trump personally intended to violate state election law, including actions that are charged in the indictment?
So the charge is falsifying business records. The charge requires, as I specified, criminal conduct that was concealed. One of the concealed crimes we allege is New York State election law. I sort of went through in our statement of facts, which I think many of you have in front of you, goes through things including text messages, emails, contemporaneous phone records, multiple witnesses. All of that will be, as you saw in the fall, borne out in a public courtroom in downtown Manhattan.
Last question is Jonah.
Yeah, Greg, the charges are related to the hush money payments to Stormy Daniels. The release from your office also mentions another woman, Karen McDougal, as well as a doorman. Can you comment on how those players are related to the charges you've brought or to the case overall?
I'm glad you put your finger on that, because it's not just about one payment. It is 34 business records, 34 false statements in business records that were concealing criminal conduct. And the earlier question about New York State election law, when I talked about conspiracy to promote a candidacy by unlawful means. Those unlawful means, we allege, include the conduct set forth in the statement of facts, which is additional false statements, separate and apart from the charged ones in AMI documents, planned false statements to taxing authorities. It is not just that one $130,000 wire payment. Thanks so much.
Mr. Brad, can you comment about any incitement of violence by former president?
At what point do you think that that order is necessary?
Well, Stephen Dreyfuss, please, can we get your first responses to that press conference from the District Attorney's Office?
Well, it was very interesting in a number of ways. One of the legal issues that is likely to be raised by the Trump side is that the indictment relies on a federal crime as the crime that the false records were designed to advance or cover up. And what he has done here is he's made clear that there are several New York State crimes that are alleged, and that would totally negate that basis to challenge the indictment. He pointed out that under the New York State election law, it's a crime to conspire to promote a candidacy by unlawful means. And he alleges that the false records that he's talking about constituted such unlawful means. He also talks about false statements to the tax authorities, presumably the New York State tax authorities. That also would be a state crime. He hasn't charged those state crimes, but he has laid out a basis to say that this crime of false business records was for the purpose of either committing or covering up those other crimes. And that's enough to make it a felony under New York state law. So I think a lot of it was addressed to those legal issues. And then he makes the point that it's not just the $130,000 payment to Stormy Daniels that he's talking about, but there are other false records that he says are alleged in the indictment. The indictment, of course, is bare bones. The defense lawyers are criticizing it for that, but that's all it has to be under New York state law. It simply has to make the allegations, and they did produce the statement of facts, which contains a lot of detail about what the underlying facts are. And as one would expect, and he's required to do, Mr. Bragg limited himself in his public statements really to what's alleged in the indictment and what's laid out in the statement of facts, without going any further about Mr. Trump, whose name he didn't even mention, or about any answers to Mr. Trump's claims about political motivation. He's playing it straight and narrow, as he ought to do as a prosecutor, and we'll see what the response by the Trump side is.
Stephen, that's a very important point that you made on that federal difference in terms of New York, because we've obviously heard the likes of Florida Governor Ron DeSantis saying he wouldn't cooperate and he wouldn't help in the process of arresting Donald Trump in Florida. Has that now reached a new level of significance, those statements?
Well, not really, because that was all, I mean, I'm giving my own opinion, but that was grandstanding by DeSantis, because he would have had he has a constitutional obligation to produce somebody with a warrant, if there had been an arrest warrant issued by the state of New York. Every other state has to recognize it. So he could not have actually prevented it, but he wanted to take a position that showed that he was on Trump's side, and one can analyze the political purpose of taking that position. He's trying not to alienate Trump supporters in the upcoming Republican primaries if, in fact, DeSantis becomes a candidate. But as a practical matter, this is all going to be treated, at least by the New York authorities, as a regular case. The question will be whether Trump either will or even is capable of treating it that way, or whether he is going to make continue to make all sorts of allegations against the prosecutor, maybe threats, allegations against the judge who's presiding over the case. He would be well advised not to do that, but his lawyers have difficulty controlling him. So we're going to see, starting tonight, where he is supposedly having a rally of some sort or an event at Mar-a-Lago, what he says, if anything, about this indictment. He would be well advised not to say anything, but that remains to be seen.
Thanks so much, Stephen. I just want to turn now back to Jessica Le Mazurier. We are going to possibly see Donald Trump making that speech to his supporters. Looking at that speech from the district attorney's office, what kind of launch pad will this now prove for Donald Trump going forward?
Let's make America great again.
Well, Alvin Bragg made it clear that nobody is above the law. He said we cannot and will not allow criminal conduct, and defended himself against claims that this was some sort of witch hunt against Donald Trump. Trump earlier today pleaded not guilty to these 34 felony counts of, and this is the crucial wording, falsifying business records. And Bragg said that, it wasn't just one payment, it was 34 of those, concealing criminal conduct. And that is what this trial is going to be about. I believe Donald Trump could face a maximum of 4 years. But now how things are going to proceed is not entirely clear. It could take months or even almost a year for this to come to trial. And it's going to be very interesting to see how it impacts Trump's run for the presidency in 2024.
We heard from Alvin Bragg. Well, we didn't hear really a lot of detail in terms of those charges. He said more will come to light as time goes on in the courts. How exactly do you expect that process to play out?
Well, as I was saying, we don't expect this to be something immediate. I think they have 45 days for the defence to respond, and then it's sounding like this may not go to trial until perhaps January or even later. So it's really too early to say. But what it sounded like from Bragg was that he believes that they have a strong case. There have been some questions about whether or not this will be too tricky to argue legally, and that Bragg could be putting himself in a risky situation moving forward with this. But he seemed to be very confident in his press conference that they had what he called new evidence that had not been previously available before he came into his position as district attorney, New York district attorney. And he said, I've been doing this job prosecuting people for 24 years. I know what I'm doing. And he thinks that he's got the evidence.
Stephen Dreyfuss, back to you. All of those anecdotes that we heard from Alvin Bragg in terms of his experience and in terms of what he had basically conjured up, do you think he's got enough here based on what he said?
Well, I think if he has, you'll note that he didn't describe the specific evidence that they intend to present at trial. But he made clear that as far as they are concerned, and he made this an important point, this is not some special statute that they've just dusted off for the purpose of prosecuting Donald Trump. He said that it's the bread and butter of the New York County District Attorney's Office to bring false business records cases. And in fact, I believe that that is the case and that they frequently bring these cases. He says because New York is one of the world's financial centers, and it's important that there be accurate business records. It's an attempt on his part to explain that this is not a minor charge, that it's very significant, and that it should be taken seriously. And I think that's the limit of really what he can do as a prosecutor, to answer implicitly the charge that this was all cooked up to get Trump. You'll note that nobody that criticizes the prosecution seems to be focusing on whether Trump actually did the acts that he's accused of. They want to talk about what was the motivation of the prosecutor in bringing the charge and doing the investigation, and was he out to get Trump? But there isn't anybody I've heard who's denied any of the facts that are alleged as to the events that took place. Nobody has denied that the payment was made. Nobody has denied that the business records were false. Nobody has denied that it was passed off as a payment of legal fees when, in fact, it was payment of hush money. The question is simply, I suppose the defense will be whether that was Donald Trump himself rather than somebody else that worked for him, and therefore Donald Trump should not be responsible, or whether they'll make an attempt to say to the jury, you shouldn't even care about this. This is minor. You shouldn't pay any attention to it. It's not worth pursuing a president about. That's kind of an appeal toward jury nullification of the law. That doesn't frequently win, but one never knows. So it will be very interesting to see what the defense strategy is. And it will certainly be very interesting to see if they put Donald Trump on the stand. As you know, he has no obligation to testify, but he has the right to testify. Most of us in the legal profession would say that it would be a terrible error for him to decide to testify in this case, but that remains to be seen.
Well, that would be very interesting if we heard from Donald Trump. I just want to go back to Jessica. Sorry for the seesaw, but we have heard from Donald Trump now saying, Jessica, that his campaign... Oh, sorry, we don't have Jessica. She has gone so we'll stay with you, Stephen. We've heard from Donald Trump that his campaign has raised over $10 million since the news of the indictment first broke. What is your response to that?
Well, as President Reagan used to say, trust but verify. But I have no doubt that a lot of people, first he said 4 million in the first couple of days, then recently it was 7 million. Now you tell me 10. I hadn't heard that one before. It may be true. I mean, he has a very devoted group of followers, but the issue is not that. The issue is whether, if that devoted group of followers gets him the Republican nomination, does that constitute a death knell for the Republicans in the general election because Donald Trump is potentially a weaker candidate than some of the other Republicans who might be running for the nomination against him? It's clear that the Biden White House is convinced that Donald Trump is the weakest candidate in the general election against Joe Biden and presents the greatest chance for Joe Biden's reelection. We don't know if that's true, but seems to be their point of view.
Well, on that point, is that the reason why we have had such a silence from the Biden administration? They haven't wanted to put their foot in it.
Well, no, they want this to be all about Donald Trump, because in their view, there's nothing good about the spectacle of Donald Trump walking into a courtroom. You know, one of the still photographs that was released shows Donald Trump in a longer shot sitting at the counsel table with his lawyers, with two uniformed court officers armed with guns and handcuffs standing behind him. That is done in New York for people who are in custody, because he was still at that point in custody, and therefore he was under arrest. That is a very sobering photograph, and you can spin it any way you want. To be the first former president in the history of the United States of America to have that accusation made against him or her is extraordinary, and I don't believe that Donald Trump thinks for a minute that it's a badge of honor.
Well, that goes back to the old adage that any publicity is good publicity for Donald Trump, certainly. But we heard that from Alvin Bragg in terms of the language that had often been used by Trump throughout the indictment proceedings and everything that followed that. I want to go back, though, to 2016 and these charges that relate to that. How big a deal would it have been to pay that hush money to Stormy Daniels? Why was it such a big deal?
Well, among other things, because he was running for president at the time, and he was trying to keep this kind of a scandal out of his campaign. His apparent view, or his campaign's apparent view, was that it would be a negative for him in the election if it were to be shown that it turns out to be very soon after his current wife, Melania, had given birth to their son, and she was still home with this infant, that the allegation is that this affair with Stormy Daniels took place. He's always denied that it ever happened. And clearly the judgment was made at the time that the payment was made, that it would have been disadvantageous to his campaign for that allegation to be made. So the allegation is that they bought it from Stormy Daniels using the intermediary of American Media, this company that publishes the National Enquirer, and they bought it for the purpose of killing the story for the benefit of his campaign. He continues to this day to deny having had this affair. The underlying affair is not of great significance, I think, to the American public. At least it doesn't seem to be, because we've become inured in 4 years of Donald Trump's presidency to the fact that he has broken all molds of what we expect a president to be. But the fact that he commits crimes in order to cover it up, it's very frequently the case that covering up an offense in the United States is worse than the offense itself. And this may be, in fact, one of those cases. The other thing that could be worse for him is if he took the stand and were found to lie under oath, because in this country, lying under oath is a very serious crime, and he could be subject to additional prosecution for that if he took the stand and was shown to lie. Another good reason for him not to testify at his trial.
Well, we will see if he does indeed testify or not. Of course, this all relates to Donald Trump pleading not guilty to those 34 counts of falsifying business records. Let's just have a quick reminder about what the prosecutors said in regards to these charges.
To falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct.
That is the District Attorney, Alvin Bragg. Any last thoughts there, Stephen, before we wrap up?
Well, he's now set out what he did and why he did it. And now it's up to the prosecutor to prove the case. It's up to the defense to try to get the case dismissed on legal grounds. They'll try to do that. If they don't succeed, the case will go to trial, and we will finally find out what a jury of 12 citizens thinks of the charges against Donald Trump. That's the way the system works. That's the way it ought to work, no matter who the defendant is.
Stephen Bragg, thank you so much. That's Stephen Dreyfuss, Stephen Dreyfuss, former prosecutor and lawyer. And we will also be coming to you with our correspondent who is in Mar-a-Lago. That's Kedevan Goldstein, and she'll be bringing us the latest as Donald Trump leaves Manhattan for Mar-a-Lago following the indictment case. That's all the news we have for now here at France 24, but there is more coming up with our Eye on Africa special. We'll see you soon with Georgia Smith. That's all for now.